It's Rick. It is December 29th, 2018. If you need to reach me because you're interested in receiving my paperwork, you're going to find out how much the gift is. The email is rick, R-I-C-K, 0327 at me.com. Okay. Email's brief. Child support only. Okay. I don't deal with anything else, just child support. And also, I don't usually say this, but I just because I don't always send the paperwork, even if somebody has the money. If I send something's not right, I choose not to interact with people. Just I reserve that right. Okay. All right. So we're looking at here. We're revisiting Coram non-Judice. Okay, because I mean I'm discovering all over the place. I mean, I've always said it was fraudulent, but it's really fraudulent. I mean, they have like no grounds anywhere. And also in this video, we're going to be looking at child support enforcement under Executive Order 12953, and it was signed by President Clinton. And what they did was they took that executive order and then they applied it to all the states. Okay, but Executive Order 12953 is only applicable to members of the United States Uniformed Services and employees of the federal government, the corporation, federal agency. And they applied it to all of us. Okay, and I'm going to show you. All right. So, theoretically, you should be able to walk into a Title 4D state hearing and inform them that they have no jurisdiction over you because you are not a member of the Uniformed Services. You are not an employee of the federal government. And under Executive Order 12953 is proof of what you're saying. Therefore, you are not subjected to child support enforcement. Because all state Title 4D laws are under the guidelines of 42 U.S.C. Section 651 through 669 subsection B. It's not my opinion. That's the Supreme Court's decision. Okay? So, thereby, if you're now in front of a surrogate judge, okay, who's a surrogate judge? They are your support magistrates, your friend of the court, the attorney general, anybody that's not a judge, okay? And they act like a judge. Well, the Supreme Court has already acknowledged that any proceedings in front of somebody who's not a judge, which is Coram non-Judice, is what you're looking at right here, is void. It's really that simple. And they can't unvoid it. So you're going to really, I get a lot of emails, people like, oh, yeah, I submitted the Coram and they just ignore. I don't know what to tell you at that point. I can only give you the information and give you the paperwork. Okay? You're going to have to make it work. You're going to have to stand there and exude confidence and tell them, wait a second, you cannot, I just got done telling you that these proceedings are void. Now, we're just talking about the Coram non-Judice right now. We're going to, towards the end of the video, we're going to talk about the other stuff. Okay, when you go in there with both of these things, really it should be over. Okay, it should be over. They have absolutely no grounds. That's the reason why they need consent. Okay, that's the reason why they need consent. Okay, and again, because these proceedings are in these nisi prius courts, which are these are presumptive hearings, meaning that everything is a presumption. Remember, I just got done telling you when the video started that under Executive Order 12953, it applies to uniformed services and employees of the federal government. All right, now it's a presumption, they apply it to everybody. You have to object now and say, hold on a second here. Objection, I'm not a member of the uniformed services, and I am not a federal employee as signed by the president under Executive Order 12953. Okay, it doesn't apply to me. You got the wrong guy here. Sorry. So, and it's going to help if you file paperwork before going there saying all these things, because they're not going to let you say all these things. I mean, you're going to try. I get it. I've been there, tried that. I mean, I didn't know this stuff. I wish I had known this when I was going through what I was going through. I knew she was fake, but I having the Supreme Court behind you is pretty nice. Okay, and again, if you read some of their paperwork that they return to you, they have no problem, citing case law. They do it all the time. I just helped a friend out, Roger, his pension plan. The lawyers that work for his pension plan, they what happened was the pension fund sent over money, so then he filed a cease and desist, and then the pension lawyers, who really supposed to be working for him, send a letter saying, well, they were being wise asses, saying that the cease and desist was baseless, which it wasn't. And then they cited all these case laws, and then they cited these other laws under 29 USC. So, he sent me an extra gift, and I went to work. It took me 3 hours, and I dissected everything. And every one of the case laws and every one of the laws did not apply to him. Every one of them. Okay? And I've seen these case laws before from other people and with myself when I was fighting my pension plan. So what happens is lawyers, they're like us. How many of you guys will cut and paste? I've done it. Like, you'll cut and paste the case laws that are on the internet about void judgments. They're all over the internet. That you can attack a void judgment any time, a collateral attack, blah, blah, blah. We've all done it. Well, lawyers do the same thing. Okay? Lawyers are lazy. So, we're going to see what happens when Roger sends that response back, because I don't know what they're going to, lawyers don't like to be proven wrong. Okay? So we'll see what happens. I'm telling you, when I tell you every one of the laws did not apply, and every case law that he cited did not apply. It was citing the employee railroad, blah, 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 ERISA it's called. Doesn't apply. Okay? So what is Coram non-Judice? In presence of a person, not a judge. Pretty simple. When a suit is brought and determined in a court which has no jurisdiction in the matter, then it is said, well, why does it have no jurisdiction? Because you're in the presence of a person, not a judge. See, in the presence of a person, not a judge, period. Done. Now we start a new subject, basically. When a suit is brought and determined in a court which has no jurisdiction in the matter, then it is said to be Coram non-Judice, and the judgment is void. Again, they have no jurisdiction. Why? Because there was no judge there. Okay. All right. This is another case law from 1880 now. Now, I did a video last year about this, and I was looking up Coram non-Judice. Coram non-Judice was used a lot, a Latin phrase used a lot in the 1800s. Okay, you don't see it much anymore. It's out there, but still. So what happened here was there was a proceeding in a state court, right? A state court before trial, and duly verified. So somebody brought here's another instance where somebody brought a writ habeas corpus, probably because somebody was jailed before a person had a judge, and then they moved it in. All proceedings in a state court subsequent to the removals were coram non judice, meaning they were before a person had a judge, and absolutely void. Okay, what don't you understand about? I'm not talking to you guys now. This is, you know, in the writings, you can put in your writings, and like, what part of absolutely void, what don't you understand? How can they dismiss a matter? I mean, listen, lawyers do not argue this stuff. I mean, this is like serious stuff. I mean, you think about all the money that would have to be returned for people whose property or money has been taken by judgments written by these judge surrogates, fake judges. Think about it. Because what I believe is, I think a lot of judges won't get involved in this. A lot of them won't, they jurisdictionally can't get involved because they're being compensated from the Title 4D money. The Title 4D money is deposited into the state treasury, and the judges are state employees. Okay, Toomey versus Ohio is the case law, and Monroeville versus whatever. But look up Toomey, Tumey versus Ohio. That's when a judge is receiving a financial benefit. Okay, and it doesn't have to be. It could be subsequent. It could be, he doesn't know about it. It doesn't matter. If the money. Oh, listen, how many? All these judges. I get a lot of people who are getting divorced, and these maniac state judges are taking divorced men who are not on welfare. The wife is making $100,000, and these maniac judges, state judges, are forcing men to pay child support through a state child support enforcement system. And why do you think they're doing that? They're doing that to make money. They're making the state money. You're getting divorced. Who else? They have no authority to tell you you have to pay child support through a 4D collection agency. Forget about it. I just got done telling you that it doesn't apply to people who, unless they're members of the uniformed services. Now, if you're one of them, I don't know how you get around that. Because when you become a member of the uniformed services, you pretty much sign away your constitutional rights, from what I understand. Okay? And federal employees, okay, I'm not sure how that works for you guys either. I'm pretty sure they still need consent, because the way I read it was cooperate. But I'm focusing on the people who are not right now, because there's a lot of people that this doesn't apply to. Okay, so let's get back to this now. Excuse me. So when you are, this is the reason why, by the way, that I have you guys, before you go to court, one of the affidavits that I tell you to file is a change of venue. I also have you file coram non judice is void, all that stuff. Again, I'm not in there with you guys. You guys are gonna have to trust me on this. You're gonna have to trust me. On my last video, I showed you how income withholding doesn't apply unless you are a member of the uniformed services, federal employee. There's fraud all over the place. Okay? Well, presumptions. So that's why we have to object. They're using presumptions. So we're going to object and say, excuse me, I'm not one of these people. Okay? Okay, so what is child support enforcement under Title 4D? Okay? All of you are going before, especially if you're in front of one of these fake judges. So now you have them as they're fake judges. Now you have this. Okay? Now you have two reasons why you're not the matter should be dismissed. Okay, you're not supposed to be issuing any judgments because you are a judge surrogate, and the Supreme Court says that any matter with a person not a judge is coram non-judice, no jurisdiction. That's it. Then you throw in, excuse me, I'm not a member of the Uniformed Services, and I'm not an employee of the federal government. They have no standing. Okay, that's what they have. They have no standing. All right, so this is Executive Order 12953, signed on February 22nd, 1995, Section 203. All right, I have it here. Remember, I was talking, it's Federal Publishing Office. Okay, so here we have right here, right, Section 203. Child support enforcement means any administrative or judicial action by a court or administrative entity of a state necessary to establish paternity or establish a child support order. You follow me? Including, how many of you guys get this? Including a medical support order. How many of you guys are being made to pay, medical coverage, right? And any actions necessary to enforce. Now we're talking about them establishing. Now we're talking about them enforcing a child support or medical support order. Child support actions may be brought under the civil or criminal laws of a state and are not limited to actions brought on behalf of the state or individual by the state agencies providing, here's the key, providing services under Title 4D of the Social Security Act, which is 42 USC 651. Okay? But who do you have to be? Actions required of all executive agencies, okay, to facilitate payment of child support. That means when you're not a member of the Uniformed Services or an employee of the federal government, you are not subjected to child support enforcement. So that's child support and establishing paternity. That's it. Okay, now here's a great one I love. State, right, means any of the 50 states. Why don't they just say all of the 50 states? You want to know why? Any of the 50 states, they mean any of these states right here. The District of Columbia, the territories, the possessions, and the Commonwealths of Puerto Rico and Mariana Islands. Remember, where's Guam? Where's the Virgin Islands? Okay? So state means any of the 50 states, the District of Columbia. Okay, but again, let's go back. Even if that's suspect, anybody could read that. Listen, I'm not even quite sure. All right, but I think they mean District of Columbia. So so let's just go back to 42 USC 651 through 669B. It's consistent that the definition of state is Puerto Rico, District of Columbia. You know why they say District of Columbia? Because that's where the federal government is based. Okay? Who's the United States? Under 28 U.S.C. 3002, that's where the United States is based out of. You know, the United States, our capital used to be Pennsylvania at one time. Okay? Then they moved it to the District of Columbia. All right? The land was donated by some really rich guy at the time. Got a lot of Finoki stuff going on. Okay? So, all right, so I just covered that. Now, who are subjected to child support enforcement under federal executive order? Members of the United States uniform, we went over that, 202 of the executive order. Employees of a federal agency under section 201, executive order 129. You know who else? Private persons under 42 U.S.C. section 659b4 means a person who does not have sovereign or special immunity. Well, you do. You were born a man or a woman. You're a people. You are sovereign. Okay? You were born sovereign. They made you into a person. You're not a person. You know why you're not a person? Because you're breathing. That's why. And you were born. Okay? You were born. You weren't birthed. I know a lot of my smart people out there, and those of you that are going to be educating yourself, you guys all know about the Admiralty, all right, and birthed, all right. Ships are birthed. Where are they birthed? Oh, over there at the dock over there. Okay, that's Admiralty. But I don't get into those videos. Okay, I try to keep it simple. This stuff can be complicated. All right, so I just proved to you guys that I gave you two instances where a proceeding where they have no standing. Okay, remember I showed you absolutely void. Look at that, absolutely void. Okay, absolutely void. There's no way around that. Okay, absolutely void. Okay, all right. So I think I've proven to you. All right, look at this. See, this is on what is this? Law Dictionary. It's Black's Law Dictionary's website. See, even they make mistakes. Coram non-Judice. All right, it's supposed to be Judice. Okay, J-U. But even they make mistakes. Okay, so when I make a mistake, I'm not the only one. Okay. All right, guys. So listen, I just proved to you guys. Now, this is why it's very important to file paperwork before you get there. I'm telling you right now, good luck saying this in court. Good luck. These people, okay, they by the time you get to these fake judges, these people are so practiced at not letting you speak and ignoring you. That's why you have to file paperwork. And I've said it before, guys. Do not let them get away with, oh yeah, that's dismissed. Excuse me, ma'am, sir, I filed paper. Oh yeah, that's dismissed. No, 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 no. I want it in writing. Objection. I require it in writing. How am I to appeal this if it's not in writing? What am I appealing? Okay? So that's what you got to do. All right, guys. So listen, if you're interested in my paperwork, okay, my paperwork is based on stuff like this. My paperwork is ridiculous now. It is so strong. It is so strong. Okay? Here's interrogatories, right? There's another thing I have you guys do before going to court. Filing interrogatories. Interrogatories are discovery. It's questions and also discovery. Now, I did a video a long time ago where I showed that they under the the manual, the 12 chapters of the essentials for attorneys, for the attorneys who are representing the Title 4D agency. I'm going to do a video on that. I can't talk. We're at 25 minutes, but what they want people to, when they're standing next to the custodial parent, the lawyer who's representing the child support agency, what they don't tell the mother or the father in rare instances is that they're really representing the agency. They're not representing, but so in the chapter, I think it's chapter 7, it's hilarious where they're wording it, well, if they ask you, basically like if they ask you if they represent, you got to tell them. So they're supposed to lead them on that they're representing them, but they're not. They're really representing the agency. I mean, it's hilarious. It's nothing but fraud. It's nothing but fraud. Okay. See, I got the nice footnotes. Okay. And you're going to send this to the child support agency. And this is more ammunition for you when you go to court, and you could say to in the instances where you're in front of a real judge, you're going to say, hey, this is all more ammunition to say I deserve a dismissal because 1, child support agency didn't answer me. 2, you're not a real judge. 3, I'm not a member of the Uniformed Services or an employee of the federal government. Hello, you have no ammunition on me whatsoever, evidence, I should say. All right, I can keep going and going and going. All right, guys, enjoy the rest of your Saturday. Hope to hear from some of you. Bye.